There was drama in the Supreme Court on Thursday leading to the decision of the court to dismiss the application for review by the National Democratic Congress, something that a lot of people, court reporters, lawyers have described as strange. And because the NDC had not gone within the timelines stipulated by court rules, they had earlier applied to the court to try to abridge the time for them so that they can make their case, also taking into consideration the legal vacation pending. Now, that was granted, and the NDC subsequently applied again orally that they needed time to go through the case and then possibly move their application before the justices of the Supreme Court. Now, this is where the problem started, or the drama started, as just when the discussion has started, you had lawyers for the Electoral Commission walking in with their responses in opposition to the application that had been filed by the National Democratic Congress. Now, in normal circumstances, you would have these filed beforehand and served on the parties so that they would have the opportunity to go through them before appearing in court. And this was what the NDC, through lead counsel Tsatsu Tsikata, asked the court for. He argued that they had just been served with the EC's responses in court, and so they did not think they had a full grasp of the responses raised by the Electoral Commission, and so could not proceed to move their application. But this didn't seem to go down well with the court, as the court insisted that the NDC had to move the application as it was. Lawyer Tsatsu Tsikata said that if you looked at the nature of the responses that came in from the Electoral Commission and the fact that he was just served in court, indeed he mentioned that the responses were filed at the court registry in the morning of the hearing, and they, as a party to the case, were served whilst they were on their feet in court, and so they did not think that they had the capacity to be able to adequately proceed with the case as it was. But this, the court did not agree with. The court insisted, and lawyer Tsatsu Tsikata resisted. And so the court dismissed the NDC, describing the case as being without merit. After the proceedings, a member of the legal counsel for the NDC, Abraham Amaluba, spoke to the media, and he did not have kind words for the decision that had been taken by the court.
The Supreme Court did the unthinkable today. They actually dismissed an application that was not moved. Indeed, what the issue was that we were served, the NDC was served with an affidavit in opposition 45 minutes before the start of the hearing. And so our lead counsel, Tsatsu Tsikata, indicated that the affidavit from the EC was just served him right in court, and he needed time to peruse through it, and would want to take a date, a short adjournment, for him to be able to assist the court by looking through the affidavit in opposition. The court will not hear any of this. Even the lower courts, if you are on your feet and a process is served you, you seek the court's leave to enable you reply to matters deposed in the affidavit in opposition. It was therefore shocking that the Supreme Court insisted that lead counsel should go ahead and move his motion when indeed the affidavit in opposition from the EC was just served on him while he was on his feet. That for me was against the practice. That for me was against the right of the NDC to enable the NDC reply to those matters deposed in the affidavit.